And we move to our last presentation by Jonathan Brossorio, who is sitting here in the front row. And he will talk about a fairly recent development as well, not within an international environmental treaty, but within an international organization, the World Bank, who in 2020 adopted its dispute resolution services, which are meant to address project-related issues, projects, of course, financed through the World Bank. And Jonathan will look at the question of how should the World Bank's dispute resolution services benefit affected people and borrower states. Jonathan, the floor is yours and the screen.
The World Bank offered a nearly $200 million US dollar credit to Uganda to build a drainage channel in Kampala, Uganda, which had recently experienced 150 plus floods. When the work began, members of the Kawala community report that they were awoken in the early morning hours by state officials and armed guards who began destroying their homes and farmlands without prior notice. The Kawala community claims that the construction of the drainage channel poses a series of environmental and social concerns, such as the floods have actually increased since the project began, in violation of the World Bank's environmental and social framework policies. The Kawala community therefore brought a complaint before the World Bank's dispute resolution services. My name is Jonathan Brossorio. I'm a PhD candidate at Paris and McGill. And I was supposed to tell you, as Christina mentioned, about how the World Bank's Dispute Resolution Services, or DRS, should benefit affected persons and borrower states. And that's the chapter that I've contributed in the great book prepared by Professor Voigt and Professor Forster. Right, thank you. I take this opportunity to thank Professor Voigt for the invitation to speak today at Fleury Court, and also the United Nations University, who has funded this research. And I'll tell you about the DRS, but for such an esteemed audience of environmental law and policy experts, I'll focus today instead on the impact of the DRS on environmental law. The reason why I focus on this topic is because the environmental concerns that the Kawala community has expressed are not out of the ordinary, quite the contrary. The number one complaint against World Bank funded projects is that they have not conducted properly the required environmental assessment. And with climate changes, it's likely more projects will be focused on addressing changes to the environment. So if there's one thing you should remember for my presentation today, it is this. The DRS should not make the burden of seeking resolution of the adverse effect of bank-funded projects, such as those on the environment, fall disproportionately on vulnerable population. So here you can see how big and how often requests focus on the lack of proper environmental assessment. Quick joke, no time for this, I believe. And before I get into this, I'll present today this topic in two parts. I'll focus first on explaining what is the DRS, and then I'll explain how the DRS should be reformed to have a greater impact on and within environmental law. So I mentioned DRS, what does that mean? Well, in 1993, the World Bank established the inspection panel as the first independent accountability mechanism at an international financial institution. So in short, people affected by bank-funded projects can complain to the panel that the bank has not complied with its operational policies and procedure, such as the one on environmental assessment, and the panel will investigate whether the bank did or not. So therefore, the panel has a compliance function, and adopts a fault-finding approach, but a compliant function within an international organization. As you can see here, the panel is separate, but under the same umbrella of a new accountability mechanism, which was established, as Christina mentioned, 3 years ago. And it hosts a new process, which is the dispute resolution services. And affected person basically must meet the same eligibility criteria then to have access to the panel. But when both parties consent to it, they have the option to go to ADR first. So either fact-finding, dialogue, information sharing, mediation, conciliation. And in that case, the panel will hold its compliance process in abeyance until the DRS process concludes for a maximum of a year and a half. And so therefore the DRS has a dispute resolution function and offers a true problem-solving approach to the parties. The mandate of the DRS was to be established in addition to, but not as a substitute for, the compliance review process under the auspices of the panel. And the bank itself has endorsed the view that the mandate of the DRS is to enhance the effectiveness of the accountability of the World Bank while being accessible and independent, and as is the panel. And the DRS was established in 2020. It became operational in 2021 under interim procedures. And the bank sought comments on how to revise the DRS process. And I submitted the following comments, among many others, in that first round of revision. And the second round was this summer, and I submitted similar types of comments. So I'll get into those now. I'll focus on 3 types of comments that are based on the 3 pillars of the right of access to a remedy of affected persons, so namely accessibility, effectiveness, and independence. So first, on the area of improvements related to accessibility, I'll focus on eligibility. As I've mentioned, the eligibility requirements are the same to access the panel in the DRS. And some of them make sense. For instance, as Christina has alluded to, that the project be financed by the World Bank, for instance, and not by another multilateral development banks. But other criteria, such as that the requirement that the harm has been caused by the bank's violation of the policies and not the borrower states, appear less relevant and may well reduce the accessibility of a remedy. In the context of dispute resolution, this criterion appears unwarranted because the goal of the dispute resolution process is to seek problem solving, not with the bank, but with the borrower state. And to the extent that consent is required from the borrower state to access the DRS, there shouldn't be the requirement of a violation of the bank's policies. So I therefore suggest that this criterion should be removed from the requirements. The second area of improvement relates to the effectiveness of the right of access to a remedy, and more specifically on the content of the dispute resolution agreement, so what the parties agreed to, the affected persons and the borrower states. In the first version of the operating procedures, it was stated that the dispute resolution agreement should be consistent with World Bank's policies and relevant in domestic and international law. In the new version of this summer, now the requirement is that if the accountability mechanism secretary believes that there is a breach of the bank's policies and domestic and international law, that should be referred to the parties. No explanation of what should be done then. But then it also adds that if the secretary believes that the agreement might bring into issue the bank's rights and obligation, it should seek advice from the vice presidency of the bank. So in that case, it seems like the revision of the rule is less protective of affected persons and more protective of the bank. It's more concerns about bringing issues related to the bank's rights and obligation. So it's quite clear that under the policy right now, affected persons can agree to a remedy that is lower or less than what is provided under the bank's policies and procedure. And my suggestion is that the bank should consider revising that paragraph to specify what type of deviation of the policies are possible and providing guidance on how to ensure that remedies accord with human rights in practice. The third and last area of improvement relates to independence and impartiality, and more specifically on the mandate of the panel. As I mentioned, the panel of the DRS, as I mentioned, the DRS was established in addition, not as a substitute for the inspection panel process. And I'll skip some of the details, but there are certain situations where the DRS mandate might actually encroach on the mandate of the panel. And what I suggest is that instead of the following sequence, first DRS for a year and a half maximum and then compliance review, the parties should have the option to start with either one and then to change once, or even perhaps to have access to both processes simultaneously, as is done, for instance, at UNDP. And on independence, I don't even touch on the topic that there is no funding available for affected persons to have assistance on representation to bring a complaint before the DRS or the panel. My overall argument is that the DRS, as it is now designed, has the potential to enhance the right of access to a remedy of affected person and have a great impact on and within environmental law. By emphasizing party like DR, it provides affected persons access to an independent third party, access to the determination of remedial measures. But at the same time, the heavy reliance of the DRS on the consent of both parties enables affected persons to agree to a remedy to some degree inferior to those envisaged by bank policies, including for harm caused to the environment. This is a real possibility, particularly where affected persons continue to bear the adverse material effect of a violation of bank policies while the dispute resolution process runs its course. Against this backdrop, the bank should consider altering the dispute resolution process to better address the inequality of power that exists between affected persons and borrower states, such as by entrenching certain minimal safeguards for affected persons. This is how the DRS, I submit, would have a greater impact on environmental law. Thank you very much.